So, in this video, we'll discuss Article 22 and that provides protection against illegal arrest and detention and the very provisions of Article 22 as under Clause 1 the very person arrested to be informed of the grounds and also has the right to consult and defend and by a lawyer or legal practitioner. And the second clause provides that the arrested person to be produced before the nearest magistrate, and that also within 24 hours. And clause 3 of Article 22 provides that this provision is not applicable against enemy, alien, or anyone arrested under preventive detention. And clause 4 provides that anyone cannot be detained no longer period than 3 months as on the very opinion or the advice of the advisory board. And the clause 5 provides that regarding communication and representation, and as it is regarding the communication, every arrested and detained person should have the right to communication and also the right of representation. And clause 6 provides that there would be certain grounds, that's non-disclosure of facts in case of any arrest or detention. If it is in public interest, then the state could not disclose the very facts of arrest and detention of such persons. And clause 7 relates the exclusive power to Parliament to make or enact laws relating to arrest and preventive detention as provided under Article 22 of the Fundamental Rights, which provides protection against arrest and detention. And now we'll deal with exactly the very relation that we found in between Article 21 and Article 22, and that is exactly relating to the position that we found in relation between these two articles and how it was expressed in the leading case Kamla versus State of Maharashtra, and it was decided in 1981, and that is relating to the very provision and the very scope of this article as relating to this. The Supreme Court expressed that it is now well settled that Article 21 may also supplement the various requirements laid down in Article 22 as it was expressed by their learned lordship In this particular leading case, Kamla versus State of Maharashtra in 1981. And now we'll go to the second important leading case which relates to Madhu Limaya, a socialist leader, and it was a case of 1969 where it was expressed by the Supreme Court that it should be noted that arrest and detention in Article 22, Clause 1 and Article 22, Clause 2 do not cover civil arrest or deportation of an alien or action by the court itself. And now we go to the third different ground, and that is information of the grounds. And in that connection, we'll discuss one important leading case, and that is Hansmukh versus State of Gujarat, and it was decided by our apex court in 1981, where it was expressed that information about grounds of arrest is mandatory under clause 1 of Article 22 of the fundamental rights. And now we'll go to preventive detention. And regarding preventive detention, we'll discuss two important leading cases. One is T. Devaki versus Government of Tamil Nadu, and it was decided in 1990. And the second important leading case relating to preventive detention. The very important case is Vijay Kumar versus Union of India, and it was also decided in 1990. So, in case of T. Devaki versus Government of Tamil Nadu, it was expressed that the state government may, if satisfied with respect to any bootlegger or drug offender or forest offender or gunda or immoral traffic offender of slum grabber, that with a view to prevent him from acting in any manner prejudicial to the maintenance of public order, it is necessary to make an order directing that such person to be detained, as it was decided in this leading case, T. Devaki versus Government of Tamil Nadu in 1990. And as regarding Vijay Kumar versus Union of India, it was expressed that a detention order passed under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, Section 3 in the Gurumukhi version stated that detention was necessary to prevent the detainee from abating smuggling. But the grounds of detention spoke of concealing, etc., of smuggled goods. The order of detention was held to be void. The reason is that in such cases, the detainee cannot make an effective representation. In this case, there was also a variance between the English version and the Gurumukhi version of the order of detention. And now we'll go to the next provision that is falling under Article 22, and that is right to consult, and under that we'll discuss two important leading cases. One is Gopalan versus State of Madras, a case of 1950, and the second one, that is State of Madhya Pradesh versus Subram, and it was a case of 1966. So, in the very important leading case, A.K. Gopalan versus State of Madras, as it was decided in this particular leading case, the detainee can be permitted to be represented by any legal practitioner of his choice before advisory board. If the permission is denied, then a clear case of breach of provisions of Article 14 of the Constitution is made out. So, also in the another important leading case, it was expressed in the very important case, State of Madhya Pradesh versus Subram in 1966, that this provision regarding right to consult is also mandatory, and besides this, there is a right to legal aid flowing from Article 21, even where Section 304 of the Code of Criminal Procedure 1973 does not apply. And now we'll go to the eighth one, that is the important leading case, Nanikaram Harchandari versus State of Maharashtra in 2016, and S. Muhammad Rafi versus State of Tamil Nadu, and it was the case of 2011, and it is relating to legal representation. So, in that connection, we will discuss that legal representation as regarding that one is entitled to legal representation as it was expressed, that to produce an accused before the nearest magistrate is mandatory, and as relating to that also, it is expressed in the another important leading case, and where it was expressed that the detainee can be permitted to be represented by any legal practitioner of his choice before the advisory board if the permission is denied, then a clear case of breach of provision of Article 14 of the Constitution is made out. And now we'll go to regarding the very provision relating to the detainee or the arrested person to be produced before nearest magistrate, and that also within 24 hours. And in that connection, we will discuss the leading case state of Uttar Pradesh versus Abdul Samad as it was decided in 1962. So, in that connection, in this particular leading case, it was expressed that to produce an accused before the nearest magistrate, and that also within 24 hours of arrest, is a mandatory provision under Article 22 of the Fundamental Rights, and as it was decided in this very important leading case state of Uttar Pradesh versus Abdul Samad in 1962. And now we'll go to the provisions relating to advisory board, and in that connection we'll discuss the important leading case Isaac Babu versus Union of India in 1990 decision, and the next one Abdul Khumi and B.L. Abdul versus Union of India in 1991, and the third one Gracie versus State of Kerala in 1991. So, regarding the first important leading case in relation to advisory board is the leading case Ishaq Babu versus Union of India. So, here it was expressed that the right under Article 22, Clause 2 of the Constitution is available only against detention by the police and not against custody in jail. So, also, it was expressed that government cannot delay consideration of the representation on the ground that it awaits the board's advice. And as it was decided in this leading case, Isaac Babu versus Union of India, and now we'll go to the second important leading case relating to this is Abdul Khumi and B.L. Abdul versus Union of India, and it was decided in 1991 by the apex court, where it was expressed that if a representation is sent to the chairman advisory board through the superintendent of the jail, the central government must consider it even when the detainee's representation under the COFEPOS Act is received after the order is confirmed by the government. The government must consider it. And now we'll go to the next important leading case relating to advisory board is Gracie versus State of Kerala in 1991. So here it was expressed by the apex court that consideration by the board is an additional safeguard. It is not a substitute for consideration by the central government. So it is an additional safeguard. The very consideration by the advisory board. And now we'll go to another facet of Article 22, and that is regarding representation. And in that connection, we will discuss another important leading case, and that is Veeramani versus State of Tamil Nadu in 1994. The Supreme Court expressed in this particular leading case that representation in case of preventive detention is to be made to the competent authority. To ascertain who is the competent authority, the scheme relating to the authority is to be examined, and it is a part of the discretion available to the court as it was decided in this leading case, Biramani versus State of Tamil Nadu in 1994. And now we'll go to another facet of Article 22, and that is relating to the right of detainee, and in that connection we'll discuss the most important leading case, ADM Jabalpur versus Sipkant Shukla, which was decided in 1976 by the Supreme Court. So, where it was expressed there are two rights of detainee. One is fundamental right, and the second one is statutory right, as it was expressed in this very important leading case. The very rights available to a detainee in this leading case, ADM Jabalpur versus Shivkant Shukla. And now we'll go to another facet, that is protection against detention. And in that connection, we'll discuss the most important leading case relating to Article 22 is Swadi Pragya Singh Thakur versus State of Maharashtra, and it was a case of 2011, and as it was decided by the Supreme Court. So, in this important leading case, Swadi Pragya Singh Thakur versus State of Maharashtra, as regarding protection against detention, it was expressed by the apex court the rights under Article 22, Clause 2 of the Constitution is available only against illegal detention by the police and not against custody in jail, as it was decided by the apex court in this very important leading case, Swadi Pragya Singh Thakur versus State of Maharashtra in 2011 by the Supreme Court, that the very protection is available against detention by the police and not against the custody of a person in jail. So, this is all about Article 22 of the fundamental rights, which deals about the right that is available under protection against arrest and detention as provided under class 1, class 2, class 3, class 4, class 5, class 6, and class 7 that we have discussed in this particular video as relating to Article 22 of the Fundamental Rights. So, in our upcoming video, we'll discuss right against exploitation, and that is available as under Article 23 and also under Article 24, and that we will discuss in our upcoming video. That right against exploitation.